right. On today's show, Judge is 95 minutes late to a scheduled 3-hour hearing. The last remaining public defender wants to recuse herself. And the juror who told the court back in August she was moving in the beginning of this year, but was not recused from cause, has now declared, I'm moving out of county. This and more on today's show. Yes, for you who ever wonder why I schedule my streams to start a few hours later than the court has scheduled the day to begin, again, this judge is always late for one reason or another. Today, 95 minutes late to a scheduled 3-hour hearing. So my thumbnail and my headline might not be correct today because there might not be time for it. So, but at least they started 25 minutes ago, not 2 hours ago. So let's go right into today's hearing. Then after that is concluded, we will talk about the last remaining public defender. And then a little bit about YSL Mondo. Okay, let's see here. Dun, dun, dun. And let's bring Mr. Jingles up. Or we can do this. And then this. Yeah, that's good enough. All right. Let's start with listening to the judge explaining why he is late today. And subtitles are on. Hello, everybody. Hello, everybody. Hello, Eva, Becca, AJ, Helen, Fun Size, EM, and everybody. Helen, I already said you, Patrice, and Corey, and everybody else who is here, and you lurkers, and everybody. And for you who will watch this on replay, hi. Remember to hit that thumbs up and the subscription button. And yeah, it's the YouTube thingies, and you all know what to do. But it doesn't hurt to remind you once in a while. But okay, let's listen to Judge and his explanation to why he is 95 minutes late to a scheduled 3-hour hearing.
Good afternoon. Mr. Williams, Mr. Steele, Mr. Adams, and Mr. Renard, good afternoon. All right, Mr. Kendrick and Mr. Weinstein, good afternoon. All right, Mr. Matthews and I should say Mr. Huey, Mr. Matthews Sr., good afternoon.
Let me know if sound.
All right, and Mr. Nichols, Mr. Harvey, good afternoon, sir. And then Mr. Ryan and Ms. D. Williams, good afternoon. All right, Mr. Uhelski, Mr. Atkins, Ms. Hilton, Mr. Brown and Smith, good afternoon. Good afternoon. All right. Okay, I appreciate y'all's patience this afternoon. I had to take up some business with our legislature today, I should say, and so that's my delay in starting. So
his excuse is he had a meeting with a legislator. That's one of the politicians, or a politician, or a group of politicians. I don't know. I don't care. Your Honor, you have a 3-hour scheduled hearing. You should name these legislators, these politicians, so their voters, whose taxpayers' money goes to this trial, can write to them and say, please, Mr. Legislator, Mrs. Legislator, Miss whatever you identify yourself as, don't take up this judge's time. Please. He's always late to begin with. We want this trial to continue or to be dismissed with prejudice. Will Mr. Judge say the name of these legislators? No. I can almost bet hard cash he will not. And whoever those legislators are, I hope they tell their voters, hi, it's me who thought my meeting with the judge was much more important than that pesky RICO trial. I have words I can't say for another 1 hour and 52 minutes and 20 seconds. Let's continue.
What we'll do is I'll get through as much as I can, or as much as we can. My hard stop time today is 4. We'll talk a little bit about what we're going to cover tomorrow, and just see where we are. But I need to take up at least, we're going to continue tomorrow with Investigator Belknap, is that correct?
Yes, Your Honor.
Okay. How long do you think how much longer do you think we'll have with him? I'm just want you to give me an estimate, that's all. Just for planning.
Your Honor, and good afternoon, everyone, and happy Valentine's Day. Your Honor, I would say 2 hours for cross-examination.
Okay, 2 more hours.
Yes, Your Honor. And I'm not sure if that's the only counsel left to cross-examine. If that is, then the state would have about an hour and a half worth of redirect.
Okay.
I call BS on only an hour of redirect. I do that right here and now. Let's time it tomorrow. I will do a recap of this tomorrow because, as per usual, we don't know when the court starts, how long the breaks will be, and how long of a lunch it will be. And tomorrow also is the Fannie Willis disqualification hearing. And I kind of want to stream that one because it does implicate what's going on in this trial. And I will explain why when we get to the section of why isn't YSL Mondo in this trial? All right, let's continue with this at least today.
Does anybody else have any examination of Investigator Belknap?
We may have some cross, Your Honor. We may have some cross, Your Honor. We may have another 105 motion.
Okay, I can save you the time on that one tonight, okay? Do an order again, okay? All right. Okay. Looking ahead, Miss D. Williams, madam, are you laid on for us to hear your motion is it the 16th, madam? Did I say it the right day?
16th at 9 a.m.
Okay, and you have everybody subpoenaed you need to?
Yes, Your Honor.
Okay, all right, so we'll still plan on doing that morning, okay? Just for planning purposes, so I can tell our jurors and we can plan accordingly. And you also know everybody's tracking that the 19th of February, Monday, is a county holiday, so we will be down that day. But the rest of the week, starting on the 20th February, will work.
Sorry, I don't know when tomorrow's Karen Reed hearing is. Broken Baker should know. He's been covering that a bit. So, and he is streaming now. So I propose you ask him. Broken Baker.
A full day on the 20th, the 21st.
If that is, then the state would
Mr. Uhelski, Mr.
I have to
Atkins,
go back a bit.
Ms. Hilton, Messrs. Brown and Smith. Good afternoon. Good afternoon. All right. As much as we can. My hard stop time today is 4. We'll talk a little bit about what we're going to cover tomorrow. And just see where we are. But I need to take up at least, we're going to continue tomorrow with Investigator Belknap, is that correct?
Yes, Your Honor.
Okay. How long do you think how much longer do you think we'll have with him? And I'm just want you to give me an estimate, that's all. Just for planning.
Your Honor, and good afternoon, everyone, and happy Valentine's Day. Your Honor, I would say 2 hours for cross-examination.
Okay, 2 more hours.
Yes, Your Honor. And I'm not sure if that's the only counsel left to cross-examine. If that is, then the state would have about this time, about an hour and a half worth of redirect.
Okay. Does anybody else have any examination of Investigator Belknap?
We may have a cross, Your Honor.
We may have some cross, Your Honor.
We may have another 105 motion.
Okay, I can save you the time on that one tonight, okay? All right. Do an order again, okay? All right. Okay. Looking ahead, Ms. D. Williams, madam,
Yes, Your Honor.
are you laid on for us to hear your motion is it the 16th, madam? Did I say it the right date?
16th at 9 a.m.
Okay, and you have everybody subpoenaed you need to?
Yeah, Friday, they will have another motions hearing. So I don't know if they will do half a day of trial and then the rest motion, or just motion, or if they just take a 1 to 2 hour break on Friday for that motion. I have no idea. It's impossible to know the schedule because judge is late and the prosecution keeps throwing in new evidence.
Yes, Your Honor.
Okay, all right, so we'll still plan on doing that morning, okay? Just for planning purposes, so I can tell our jurors, and we can plan accordingly. And you also know, everybody's tracking that the 19th of February, Monday, is a county holiday, so we will be down that day.
No court Monday, okay.
But the rest of the week, starting on the 20th February, we'll work a full day on the 20th, the 21st, the 22nd, and half a day on the 23rd. Of course, that's always subject to other things that are beyond the control of the court.
Okay, so next week, Monday, no court because President's Day. Tuesday, Wednesday, Thursday, full days. Friday, half a day. But as he said, beyond my control, there might be things that it's your courtroom, Your Honor. Jesus Christ.
But we'll do the best we can. The reason I asked that, counsels for the state, is it is likely based upon the representation that we may or may not be finished with Investigator Belknap tomorrow. That'd be the 15th. And is there any other witnesses or any other? What's your plan at that point in time to call witnesses?
If we don't finish with Belknap tomorrow,
If we of course we don't finish it, we'll continue on to Friday. But we should finish, do you have some other witnesses lined up?
yes, we'll be ready to move forward.
Okay, in particular, are any of those witnesses the subject of Mr. Steele's motions that I still need to address?
Yes, motion number.
Yeah. So the judge has still to hear and rule on motions regarding witnesses the prosecution wants testifying on Friday. These should have been handled pre-trial. But this judge, and you all know it, I've said it before, this judge pushes everything until the last very second because he can't make a ruling if his life depended on it.
And motion
Okay.
number 42.
Okay, give me a second right quick. Okay, motion number 40 deals with certain purported jail calls.
Yes, Your Honor.
Okay, and then what's the other one?
Motion number 42.
That's Mr. Bean, is that correct?
Yes, Your Honor.
Okay.
And then last, for the next set of upcoming witnesses, be motion number 43.
All right, I'll see what we can do about taking care of those as is necessary. I'll also include, Mr. Steele, your letter to me yesterday of 2 pages with the motions that you have outstanding as the next court exhibit in order.
Can I inquire of the state for a second?
You can, sir.
Characteristics says, I have a feeling by the time we get to defense, people should be complaining about the burden on the jurors and the defense's pay. I would not be surprised.
We're going right to Adrian.
I would not be surprised at all if the judge limits the time for the defense. I would not be surprised at all. Sadly, I should be.
We're not doing that next. We're doing
I'm
Adrian.
not.
Am I sure those are the only ones? I believe. To double check first, but I believe it's just those 3.
Okay,
You want me to please support?
not yet. Thank you.
No worries, defense.
Tim,
When the judge is 95 minutes late, you're better than the judge. Or is it Devon? I don't know. Devon's more? Devon? I don't know. Sorry for butchering your name.
Okay, the other thing I want to kind of take up with you of
Here comes the juror.
is that
Well, he doesn't.
that is the court, has gotten some correspondence with juror number 204. I'll repeat, juror number 204. Juror number 204,
I'll spoil a bit for you here. Juror 204 announced back in August that he or she was moving out of the county in the beginning of this year, February or March, depending when her lease on her property or house or apartment was done. Mr. Steele told the judge, well, this could be an issue. You should take her away by cause. And the judge didn't. And here we are. Juror number 204 announces to the court, hey, I'm leaving now, as I told you.
ladies and gentlemen, is forwarded the court a copy of her lease. And she is moving out of the county starting on, I think the lease contract begins on the 26th of February of this year. So, I want you all to think about what, I don't need an answer right now, but I do need to account for, of course, I can't make her not move. But the question is, and the court is trying to, grappling with is, must a juror be a resident during the entire time of trial?
You ask, are you going to make her travel from outside of the county to the court each day while only getting $25 a day? Seriously, if you will bankrupt that poor juror. I mean, I don't know where the juror is moving, but out of county. Well, if from the courthouse and in one direction, it might be 45 minutes to an hour. In the other direction, that could be a 3-hour drive one way. We don't know. And here he is, knowing he could have excused this juror by cause, and tries to find a way to keep that juror on.
It's not one of these situations where we have the applicability of, while we have jury selection and before our jury's impaneled and sworn, but I do believe that it may trigger 15-12-172. And looking at some case law that I've been able to kind of look at so far, and I'm going to include the juror's lease as the next exhibit in order. I'm going to order it to be.
And here's the thing, even if you have case law on it, that case law does not, that might be a 3-day trial or a 1-week trial or a 2-week trial, not another 6 months.
Sealed because it has some proprietary data in there, but I can tell you that I have matched that particular person's name with our juror list, and they are juror number 207. Okay, all right. 20. I want to make sure before I tell tales. That's good. Hold on. 204. Yes, you're correct, counsel. I apologize. 204. Okay, so I invite you all to look at, and like I said, Bell versus the state. That's 366 Georgia App 743, and it talks about trial court's excuse of a juror, replacement of a juror with an alternate. Either I can conduct an evidentiary hearing or I cannot, depending upon what is produced. So she's produced a lease. It's clear she's going to move. The question for us is, will her moving statutorily prevent us from keeping her as a juror? I haven't found any case law that would indicate that, of course, you can be removed for a juror if you're not a resident at the time that jury selection or before a jury is impaneled or sworn. But after that, the court's concern is whether or not she will still be a qualified juror, given she doesn't live here. So think about it. You all can do some research. I've done some, so has Mr. Kearns, but that is the question that we need to kind of answer before her lease takes effect on the 26th of February. Okay?
Yeah, 26th of February will be 2 Mondays. In 2 Mondays. 12 days from now. And he's acting as if he doesn't know. He is the one who forked up. He could have excused her for cause back in August. He was reminded by Attorney Steele that the trial could take a good while. And the judge refused. Another horrifically bad call.
So I'll circle back with you about that.
Can I add something to that, Your Honor?
Yes.
And please check the record because that would be best. But I believe I moved for cause. I believe if this is the right juror in my mind, she told us that she would be moving during her questioning on individual voir dire, and I believe I made a motion for cause for that reason as well as others. So I just don't want later you to say, why don't you raise that to me in my consideration because I don't want it to be a waived issue at all. So I just want to tell you that. If I'm wrong, though, I, of course, bow down to the record of John Court Reporter, but I believe that's true.
Yeah, I'll have to take a look at our notes as well, Mr. Steele. And I believe that given the fact that we didn't know whether she would move or not, and then also this has been, it took us 10 months to go through the jury selection. So I believe that if memory serves me correctly, this is a juror that, she didn't know whether or not she was going to move or not, but we'll search the record and find that out. So Chris, can you look that up for me? Okay. All right. But just,
in Christina English, did we hear anything about the one of the lawyers withdrawing? There is one lawyer who has motioned to be withdrawn. We will talk about that after the hearing.
I need you all's input, at least in terms of whether or not she's still a qualified juror if she moves. And that's what I'm trying to kind of ascertain at this point. All right, so we'll circle back with that issue in terms of I'd like to take it up maybe tomorrow, just so that we don't run out of road.
You're running for scheduling. Are we starting at 9 a.m. tomorrow?
That's a fun one. No, you're not. This judge has installed.
That's what time everybody's supposed to report. 9.
Thank you.
And we'll get started somewhere between the 9 and 9:30 hour. Okay. All right. Okay.
Can this judge put himself in contempt of the court? Because if he says we will start between 9 and 9:30 and he isn't there till way after 9:30, can he put himself in contempt? Just asking the question. Judge is having a red item on his chair. He's a gang member. Boogly, 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 boogly. Look, prosecution. Judge is having a red item on his chair. According to you, that's a sign of being in a gang.
Hey, Wes, where did you put all those notes and everything that I have from our jury selection? You upstairs? Upstairs. Where are they? Sure.
Forget about that. Skipping ahead.
App 7. Now I'd like to move on. Mr. Matthews, what were you going to tell me?
Just for the record, to let the defense bar is unable to access the internet to get all these cases and things that we need in order.
What cases?
Well, you just cited 15 you cited the statute.
I printed that before I got here. So
I think you cited a case.
I did Bell versus the state, 366 Georgia, app 743.
We just don't have access to that.
Yeah, we're still having some technology challenges from our recent situation that's belabored our county. So,
oh yeah, Fulton County has had severe weather and flooding, and the entire court system was down for a few days, and they are still having issues with that. So that's actually not on the judge. That is God saying, for frick's sake, stop this travesty of justice.
doing the best we can. Been doing the best we can with that issue. Let me check with our technical support folks and see if there's anything that, you're talking about the general Wi-Fi?
Yes, Your Honor. I think I can.
Okay, all right. I made an inquiry.
Thank you, Judge.
Okay, all right. So, Mr. Steele, let's handle motion limit number 40. I believe that talks about recorded jail calls on behalf of Mr. Williams. All right. Okay, so, Your Honor, these do deal with Mr. Williams' jail calls, but for the purposes, can you tell me what dates you're talking about, sir? For the purposes of today, for the next series of witnesses which deal with Mr. Bean, B-E-A-N, Your Honor, what occurs is on Mr. Bean's another motion. I believe that Mr. Bean is, let's see which one you have in terms of that. I could do that one, sure. I'll be right back. Mr. Bean is your motion number 42. Mr. Williams, number 40, deals with any of his jail calls.
Yeah, so that's not coming up. I know you want to do motions that are really coming up. Mr. Williams is not, to my knowledge, his jail calls are not coming up. So with that being said, I could argue 40, but 42 is really ripe for what you instructed us. Is that true state, or do you, in terms of?
I guess we understood 40 to deal with a jail call in which Mr. Williams is referenced.
Is what Mr. Williams is what, I'm sorry?
Is referenced, so that's what we thought number 40 referenced, which was a jail call in which Mr. Bean talks about Mr. Williams in that call.
Number
If that's
42.
not true.
That's number 42.
Yeah, they want to have in a jail call where a Mr. Bean talks about Mr. Williams. Complete hearsay. But it's so stupid. Yeah, it's Mr. Bean. Rowan Atkinson was in Fulton County Jail. No, but it's so stupid. They couldn't. Yeah, yes. Let's just listen to this travesty.
The one that is in 40 is broader. It just gives. Well, that Mr. Steele claims that you all will attempt to play jail calls of other persons, not Mr. Williams. So it's kind of, that's broader than in 40, that's 40. And then 42, which indicates a 911 jail calls and the like of, and it talks about a conversation between, or it says Mr. Bean and Mr. Bean's wife and an unknown male.
Yes, so then you're correct. Then we only need to hear, for the purpose of today, 42 and 43.
Okay. And then 43 covers DNA reports from Acts 5, 6, and 7, correct?
Yes,
Okay.
Your Honor.
All right. So let's deal with the phone call again with the one that references Mr. Bean. In motion number 42, sir.
Yes, sir. Okay, so Your Honor, what happens is it is the 13th day of September of 2013, and Mr. Bean is going to be in a car along with Mr. Prethro, which is Pretho. His first name is Fred or Frederick, as well as Mr. Walter Murphy. The car is parked in an apartment complex. Law enforcement officers are in that same complex for a different reason. Mr. Murphy supposedly walks up to a man named Mr. Dotson, which is D-O-D-S-O-N. Mr. Dotson has a large amount of currency on him. He's with his brother at that point. Mr. Murphy tells Mr. Dotson, you know what time it is allegedly, and tries to arm rob Mr. Dotson. Mr. Dotson, Your Honor, tragically has passed through, not this incident, just as the years went by, he's passed, unrelated to this case or this incident. Mr. Bean is driving. He says he's driving a car. The car then has Mr. Murphy get in it. The car almost kills or strikes a law enforcement officer. Law enforcement officers are shooting at the car in self-defense and to stop the car from hurting others. The car goes through a gate at the apartment complex, goes a short distance, then careens through a person's yard, takes out part of the house, a tree, and it goes off a careen, goes flying in the air, flies over a parked police car. It's just sitting in a parking lot, flies over that police car and slams into the side of a laundromat. It's on Cleveland Avenue. Occupants are either running or around the car. Law enforcement officers are on the scene. Mr. Bean gets away for a short distance, gets over a fence, and he's hit by a police car. He goes underneath the police car. He's arrested. Mr. Fred Prethrow is found right at the car. He is shot, Your Honor. Police were shooting at the car. There's some bullet trajectories that crash in through the windows of the car. And then Mr. Murphy is shot in the leg, and he's arrested at or in the car as well. So 3 people accounted for. The issue then becomes there are law enforcement officers on the state's witness list who say that there are 4 people who exit that vehicle. There are some law enforcement officers who say 5 people exit that vehicle, and there's some law enforcement officers who say that 3 people exit the vehicle. Mr. Bean Mr. Murphy is then interviewed he's taken to Grady Hospital. He's interviewed. It's not recorded. And he allegedly states that there were 4 people in the car, according to law enforcement. Mr. Prethrow is interviewed at Grady Hospital. He supposedly says it's on recording. There are 3 people in the car. And Mr. Bean is in the Fulton County Jail. The Honorable former or retired Detective Quinn gets the case, and he gets involved because it's a police officer shooting at the car and shot Mr. Prethrow potentially. So he's investigating that for the APD. And he's also at the scene, and he pulls jail calls. There's approximately 11 jail calls of Mr. Bean. During the jail calls, Mr. Bean discusses things like, I should have run with Thug. He got away. I should have followed Thug, things like that. I'm fine as long as Mr. Bean is a witness. We'll confront him and cross-examine. The issue that we raised before this honorable court is there's an unknown person. I don't know who the person is. To my knowledge, in the state, of course, will correct me. That person's not on the state's witness list. That person's not been identified in discovery. That person's on the calls. There's one call specifically, and I put it in Mr. Williams' motion limit number 42, the specific times. And that person is saying, I spoke with Thug. He said $150 was his for lien that was found in the car or left in the car. And this person's talking about Thug. I'm presuming.
This is so many levels of hearsay. So many levels of hearsay. But I do want to, this is the one video of that event that I actually want to see. But as Mr. Steele describes it, I kind of want to see that video at least, if there is one. But besides that, in my opinion, my personal opinion, speculation, whatever, this is hearsay upon hearsay. And if one of the callers cannot be identified or isn't identified, maybe it's Mr. Mondo, who knows? But if they can't, cross-examine one of the people in that jail call, it shouldn't be allowed in.
For purposes of this conversation, that Thug is Mr. Jeffrey Rose. So I can't cross-examine, the Honorable Chief Adams can't cross-examine that unknown person, and I am asking this Honorable Court to redact any of the statements made by the unknown person. They are hearsay. They are not confrontation clause, because I'm not saying that it's being used for trial evidence, for testimony, but I am saying that it's just straight hearsay. The state alluded to the fact that this would be a rule of completeness issue again, and therefore It has to come in to show context. I've listened to that recording. There is no reason to have those hearsay statements come in under the rule of completeness under 24-1-106 because different from, let's say, the tweets that the Honorable Court has listened to and ruled upon, these statements are independent. Mr. Bean is the one saying you don't need to explain Mr. Bean's statements when he's talking about Jeffrey Williams to have this other person say, oh, and since this time I spoke with Thug and Thug said that he left $150 in the car. It was for lien and that was his money or something to that effect. So that is what this motion targets. There's another recording. It's Mr. Bean and his mother. His mother is not on the witness list to my knowledge. And again, the state, correct me if I'm wrong. And I don't see why the mother's conversation with Mr. Bean should be played for the jury either. I mean, Mr. Bean's statements are one thing, but not the other person. In addition to that, Mr. Bean, so this happened on the 13th of September. On the 17th of September, Mr. Bean is brought into the Atlanta Police Department interrogation room with Detective Quinn. It is audio taped. It is video recorded as well. And Detective Quinn goes through Mr. Dotson, who's deceased, Your Honor, will not be testifying, God forbid. What Mr. Dotson said, and he talked about Jeffrey Williams. He talks about that the people at the hospital were lying to the police, he believes. So I'm moving to redact all of those statements as well, because that would be based upon, just interrogation, but it would violate Mr. Williams' right to confront it, because that is testimonial, because that is, of course, the detective who is accumulating information to potentially bring a case. Your Honor, I'd like you to also know this and take this in consideration. If you look at the indictment, Overt Act 5, 6, and 7 deals with Mr. Bean's incident. Jeffrey Williams is not named. So I had no notice that Jeffrey Williams is involved in this at all. I did get it in the discovery, of course. And this came, I believe, in discovery number 1. If I'm wrong, it was discovery number 2, but I knew about I listened to these recordings back in, 2022. So I just want you to be aware, we're not charged, but I also want you to be aware that I have had these, discovery appropriately. I'm not saying that it was thrust upon me at the last moment. I think I have case law for you, but it's a straight, not rule of completeness. I don't see any exception to the hearsay rule at all. It is an out-of-court statement, often it's evidence to prove the truth of the matter asserted. This unknown person saying, I spoke with Thug and he said that he left money in the car that would tie Jeffrey Williams to the car. Mr. Dotson's statements to law enforcement would be, of course, confrontation clause as well as hearsay. And what Mr. Dotson said, just for you to know, and I'm not saying the state's trying to use Mr. Dotson, but in case they are, it's a recorded interview. On the day of the incident, Mr. Dotson is with Detective Quinn. He's very animated. It's video, audio, and he's standing up and telling Detective Quinn, I saw Thug earlier. He saw that I had money on me. He wanted to know if the person who seemingly is selling lien has contacted me because he's not calling Jeffrey back. Jeffrey asked if he can use my phone. It must have been Jeffrey involved because his guy, meaning Walter Murphy, his guy is the one who armed robbed me. So I'm moving to exclude that as well. And that is mentioned at times by Detective Quinn when he's interrogating Mr. Bean.
So the statement you're asking to redact the statements of Dotson that Bean talks about, or what?
Yes.
During the September 17th interview?
Yes. So that's Detective Quinn repeating.
Because Dotson is deceased.
Right. And that would be confrontation clause. All right. And then, so it's 3 things, I guess. Anything that Mr. Dotson said, confrontation clause, anything that former detective or retired Detective Quinn said about his investigation to Mr. Bean, and then on the jail call, specifically the jail call with the unknown person, anything that person said, I don't believe it all fits into.
Why wouldn't Detective Quinn state, he's going to testify?
Yes, he's going to testify.
So why would I have to worry about anything that Detective Quinn says, because you're going to be able to examine him, right?
Right. But if he said, I'm making it up. He said, well, the reason I asked that question because Mr. Dotson told me that you would be getting an objection on confrontation clause because I can't cross-examine the speaker. That's what I'm saying.
Well, I'd have to take that up depending upon what he says.
Yes, I have no problem with his his in-court testimony. I'm more focused on the recordings, if the recordings are sought to be played.
Does the recording mention anything about Detective Quinn referencing statements by Dotson or?
Yeah, the jail calls. He plays the jail calls in the recording.
Okay. All right.
And that's all I want redacted. I don't mind anything about what you said is correct. Adrian Bean's going to testify whatever he said on jail call. If that's otherwise admissible, no problem. It's just
no person.
Yeah, exactly. That's it.
State, what's your take on first, like the the September 13th phone calls from the jail on the unknown person?
Yes, Your Honor. So Mr. Bean is going to be testifying as a witness. And so the admissibility of those jail calls.
Don't worry about Bean. Tell me about the unknown person.
Yes.
How is there some theory that I'm going to be able to admit that?
Yes, Your Honor. So
What is that?
Jones v. State, which is 339 Georgia App 95. It's a 2016 Georgia Court of Appeals case.
What's the site again?
It is 339 Golf Alpha.
Okay.
Yes, Your Honor. 95. That case involves an informant jail call with the defendant. They didn't have that informant testify at trial, but in the pin site for this.
Oh, you ass. That is not an unknown person. And you know it. Just because he didn't testify at trial because he was an informant does not mean he is an unknown person. Two different scenarios, in my opinion.
Is 101 and then it carries over into 102. Trial court ruled that the informant's statements were admissible to provide context for Jones's responses to those statements, not that the informant's statements were admitted to prove the truth of the matter asserted. And as for when they go on to say that the defendant's own statements, of course, are statements of party opponent. The reason that, Your Honor, I started with Mr. Bean and his testimony is because these jail calls, if they come in at trial, would be after Adrian Bean has testified to impeach what he does or does not say. So it kind of hinges on the questions asked of Mr. Bean, how he responds to those questions, and if the state can impeach him with these jail calls, that's when these jail calls would come in. And Your Honor, I'll give you a brief example that Mr. Steele kind of highlighted that explains why this Jones case is important.
So you're not trying to
Exactly.
tell the court that
Informant
you're not
secret
seeking to introduce these jail calls
unknown.
At this time, but they're dependent upon what Mr. Bean says.
Correct, Your Honor.
Okay. All right.
And Your Honor, if the court would like, I can.
I disagree, but that's just me. But because it doesn't really matter what Mr. Bean says, you can impeach Mr. Bean on Mr. Bean's words, not unknown's alleged words. Because if that person is unknown, you can't cross-examine. You can't. He or she or a dog, I don't know, goes on the stand. Yeah, it was me just trying to act important. But he or she or dog is not. It's an unknown. It doesn't apply, in my opinion.
Continue, or there was an example I was going to use to explain why this other party's statements could potentially be needed to impeach Mr. Bean. There's an example where that individual says, Thug says when Big Fred jumped out of the car, the police were still shooting. Mr. Bean responds, hell no, that blank probably shot because him and Big Fred and DK had the strap. So if you just played where Adrian Bean says him, it's in relation to this statement that immediately precedes it, where he says Thug says. So that's just one example, Your Honor, that may or may not come out. It all depends on how Mr. Bean testifies, who, of course, is subject to cross-examination, will be on the stand in person.
Okay, but there's a fair number of statements from an unknown person that,
If the unknown person can't be on the stand, then the answer 2, because the answer 2 should be out, because you can cross-examine on it. I heard that. I heard from this unknown. That's hearsay. I replied to this unknown. That's hearsay.
you all have the tape queued up?
I do, Your Honor.
Okay. Let me hear it, or the call, just mark it as a exhibit for purposes of,
Yes, Your Honor.
Why?
There's multiple jail calls. I'll pick one where this individual speaks as an example from court.
He's talking, Mr. Seals identified, the first one is 4:30. There's an unknown male talking, so start it maybe about, about 4 minutes out.
Yes, Your Honor. Can you give me screen sharing? Yes, thank you, sir.
Skipping ahead. You're already 90 minutes late, and now we are wasting time on playing a jailhouse call from where an unknown.
Call from this call. An inmate at Fulton County Jail. This call is subject to recording and monitoring.
Yeah. By the way, what you hear there, that is played to both the people on the line, and they still talk about don't confess to crimes on jail calls. That's not even legal advice. Don't call. And if you do, talk about the weather, talk about how much you love your mother. I don't know. I don't care. But don't talk about the crime you're in on. It's...
Accept this free call. Press 1. To refuse this free call, press 2. Thank you for using Securus. You may start the conversation now.
What up, man?
I mean,
Shit. Man, know how that nigga, man, them nigga that got killed, boy.
Fuck you talking about, man? I said that shit.
Little nigga DK shot at 12, nigga.
Yeah, he said it.
For no reason.
What's going on now?
Bro, when the high level.
oh, I don't know, man. I got Daisy and the guy on. I'm sure the food came over. They came over about 8 o'clock. Yeah, so we
Nah,
both
this
came
guy,
out.
right quick, so I can tell him something right quick.
Go.
Roll out.
I do this shit over.
Your Honor, that's what the right before this third party gets on call at 4 minutes.
I need someone to translate from Jive.
So you got minutes on the phone.
Bro, what's up, man?
What to do, Brody?
Right?
Hell yeah, man.
I just talking to the store, man.
What they talking about?
Shit.
Man, know how that nigga, man, them nigga that got killed, boy.
Fuck you talking about, man? I said that shit.
Little nigga DK shot at 12, nigga.
Yeah, he said it.
For no reason, boy. He shooting for no reason, though.
That's why they started shooting this out.
Man, that nigga just stopped, boy, for no reason. Call the little young guy there. I'm like, hell no, boy. Hit big friend, hit his ass. Me and Thug got there. We get out the car and run. I just went the wrong motherfucking way, man. I should have fought Thug at.
Fuck that wall.
For a reason, though, man. They got to get the shit off his back anyway.
For sure, bro. Yeah. Hello?
Yeah, I'm here.
Yeah, man. Damn, bro. We had to go like that, man.
Nah. Everything for a reason, though, man. You know what I mean? It was all set up. I did the same thing I did. Turn around, got them last night, got them talking that bullshit. But I ain't gonna never got them do it like this. I never do this, man. Ain't no
What they got you charged with, bro?
shit, but the punk ass little driving license, split license was charged. Got them the aggravated assault. I ain't charged with none of that shit today. I could have gave AC 90 and been at home, child, man.
Yeah, that's what I thought you did. I kept telling you, don't tell me,
I just thought
man.
that I was a victim, man. I had to take out raw, man, and they was shooting at me, and I was running for my life.
For sure. That what's up, nigga. Cause goddamn APBK them pull out on that boy. All they know is red, them that nigga real trying to rob y'all.
Yeah, that's what they said too.
For sure. They just let that nigga out.
Go around, man.
They just let that nigga go, bro.
Yeah, they let the nigga go, man. Me and that nigga, he ran. I wasn't too far from him.
No.
He went to Mickey D, nigga. I went from around the laundromat to goddamn that Dollar King over there, trying to make it over there through Little Haiti for Cleveland E, goddamn, up through the top of that, and I go hit Jamal in my old apartment, goddamn, go down that shit with Big Nick, you know. But shit, man, that whole goddamn come out of nowhere, boy, run me clean over.
That was goddamn double through, man.
Big Nick out.
Yeah.
I went to the car.
Yeah, they ran me smack ass low, man. My mom broke my goddamn collarbone and shit, man.
You alright, though, bro?
Big ass knot on the back of my head.
That nigga escaped, bring the police back to the spot, bro.
He did.
Yeah.
Okay.
Hey, what they trying to get the fucking call?
Yeah, what they told him, come bring him to the person who he let the car to.
No, he's come goddamn. I've been down here chilling with Bean. He been staying down here and all this and shit.
I'm supposed to call fucked up.
Yeah.
You don't even look like a nigga to survive in that motherfucker.
Fuck you so much, nigga.
That shit,
Hey, man.
that shit breaking the news all day long, man. It's like that busy on news all day long.
I'm on the news?
Yes, sir.
My picture and everything?
No, they just show you get the police on.
Oh, shit, man. I made the news.
That shit everywhere, man.
Damn.
Yeah.
Man, that was good, man. You know, like I said, everybody out for a reason, though, man. Fuck it.
For sure,
I don't know shit with nigga like that anyway, so.
For sure, man. That's it, man.
But I can't even think about this. All I can think about all them I just told babe, you know what I'm saying? Like, this shit crazy. This shit don't even seem real.
Fuck man, broke up with these niggas, man.
You drive your own shit. I don't give a fuck what's going on. You feel what I'm saying?
Because, like, nigga, you just stay here. We went to Ken shop first, right? But, you know, when you see shit, man, you gotta go on and get that shit. You know what I'm saying?
Like, going to get, bro, I said the same thing.
Man,
Like,
when you gotta go on and get it right then. Man, we got them going back to the Ken shop. Okay, they coming out of the Ken shop right there by the Chevron. Boom. Damn, man, they ride. I see them, I turn around, I'm following them niggas. I follow them niggas all the way up there on some of them. So, okay, cool. So we see the tire. I said, give me a chance and let me see what the fuck this is in the tire first before you even get out the car, DK. Man, that nigga hopped out the car, man. We just started busting. Wow. 12 got them bag up, turn around, bag up. Niggas by that time now trying to turn around and get up out them motherfuckers. They run and hit me. Boom. Bought the car. I rushed in through the goddamn gate, through Summerdale on the opposite side. Boom. He shooting through the car. Boom, 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 boom. Man, I'm talking about, man, I'm talking about bullet car sprint clean through the window, boy, down the like it had went through my head, boy. I got my head that came out my face, boy. Bullet car clean through that motherfucker. Boom. Then I believe one of them niggas in the back shot me 12, man. 12 shit. Big gun, DK had to shoot that nigga. Three shots went off in the car. And we were jumping them hills and shit. So I was like, damn, boy. After we fair, I'm glad one nigga didn't just hit me in the head and shoot me, boy, cause some nigga ran.
That nigga said goddamn Big Fred got out the car, the police shot, they was still shooting.
Nah, that nigga probably shot Big Cook. Him, Big Fred, and goddamn DK had the strap. I wouldn't even strap my 22 at home and my AR in the trunk. You get that $150 off cup holder, bro?
No.
You got that $150 off my cup holder?
No, someone say he had $150 to go buy the ring.
Nah, man.
With no money in the car.
I have no clue. One of these is one of the people in jail, and one of the people in this jail call is the unknown. What I'm trying to find out while we are listening to this is there an scintilla of evidence that the unknown is YSL Mondo? I'm trying to find that out, because if it is, that means, I hope, I so bad wants YSL Mondo to be involved in this trial. And the reason for that is that YSL Mondo, who supposedly is one of the founders of YSL and should be in this trial, is not mentioned in this trial because YSL Mondo, his lawyer in 2019 was Fannie Willis. And we will talk more about that after the hearing.
Oh, my motherfucking money.
Yeah, he said he had the money to go buy the ring.
No, I think I had another $50, $40. He didn't have that because DK didn't even get him his 50. All that money was mine, and money came out of both hands. Well, he ain't had no business doing that. He made Buck goddamn come off 100. I told him, hell no, nigga, goddamn, go 50, you go 50.
Nah, Buck, so we got young hungry pig.
No, they gave me nothing. I had a 50 of my own money. I had $350. They got $345. I got to let Bay come down here and goddamn go to property and get that shit. Come down here and sign a piece of paper. I got to fill out a property release form or a waiver form. So she can go down there and get a little $350. You know what I mean? And ain't gonna be that. I don't think I just gotta do it. Goddamn, just try to make sure them lame don't even come to court with dad. Goddamn, because they talking about the old man and that old boy.
So yeah, for sure. You know, I'm gonna take care of that too, bro. You know, I'm gonna talk to these folks.
You know, he come. You know, I mean, cool with.
Yeah, we're gonna try to keep his ass out of that, though.
I can't get no more from probation, man. I ain't got no probation, no record, no none of that shit, man. You know what I mean? I don't shoot, folks.
Yeah, we're trying to get your ass out, man. Trying to get a bond, man.
I don't rob. I don't do none of that shit. So, you know what I mean? I don't have none of that shit on my record. So, I'm good, man.
I'm just talking to Ford, man. Ford ready.
Yeah, I turned off the monetization because this stream will never survive a monetization review. So absolutely zero ad revenue or anything for this stream. If you want to support me, become a member. It's $3 and or super chat a question or something. Yeah, this won't bode well for my channel.
Oh, we.
Mm-hmm.
Oh, y'all left.
Yeah, I talked to him.
Okay, he came up cool and I talked to him yesterday.
What he say?
Shit. He ain't say shit.
Yeah, goddamn, he got some bad, whatever, goddamn, you know what I mean?
Nah, cause you know, he just said, you know, in that moment.
Man, just trying to think about what nigga done did and all that.
Yeah.
But I ain't did shit, so he know I got something going on. He got to go get me, cause I got something going on.
For sure, man. I'm gonna come back to you.
Oh, shit, cuz I know you late.
No, you cool. Got 1 minute.
Nah, I ain't saying shit, man.
Oh, you said it, man. What you want me to do about allow them in the car note in the rent, bro?
Huh?
What you want me to do about fill out with the car notes in the rent?
Shit, that's what I was saying. I got these little $345. I might just go for the rent. Car note gonna be goddamn a couple of more days. How long we got on the car note? About 10 days?
Yeah, bro.
Huh?
You want me to pay the rent first?
Yeah, I gotta get that rent. That's what I was working on this time, that rent.
All right, just found out. No, none of the voices in this phone call is YSL Mondo. I assumed it wasn't, because if it were, the prosecution will never mention YSL Mondo, because as soon as they do that, there's a whole can of worms opened up. But I do know that the defense will take every opportunity, especially now with all the Fannie Willis and her unethical behavior coming out in the open, her lying in church to get away from her misconduct. And that is one of the reasons I will stream tomorrow's hearing. I want her nailed on. Yeah. Well, phrasing, not the Nathan Wade kind of way, but I want her dirty laundry out in the open.
Yeah, what's up? I got that. Don't worry about it. Let me take care of that.
I just need like $6. I got $3.45 downtown, man. They ain't my money.
You know, I got the rest of the money you gave me in that good lockdown and shit. I'm gonna get the rest of that money.
Okay, so what exhibit was that number, sir?
Your Honor, I will mark that,
And hello over at Rumble. For you who are here on YouTube, if you prefer Rumble or if you have a Rumble account, please pop over there and give me a follow. And the link to that is
Your Honor, I will mark this jail call as Mike Tango November 4 November.
All right, skipping forward.
Context. Context, I should say. How do you claim provides context?
Yes, Your Honor. So an example would be in that exhibit that was just played, kind of near time at 9:38. So say Mr. Bean said no one had any firearms in the car. And you have this statement from Adrian Bean where he says him, Big Fred, and DK had the strap. I wasn't strapped because mine 22 and AR in the trunk. That jail call portion of Adrian Bean, who's testifying, where he says him, Big Fred, and DK had the strap, to give context to who he means by him, the immediate seconds before it is where that party says, Thug says when Big Fred jumped out of the car, the police were still shooting. So the state's not trying to introduce Thug says when Big Fred jumped out of the car, the police were still shooting. So the truth of that statement is to give context to Adrian Bean when he's mentioning him and the parties. That's one example that I think highlights where this could come up. And all of this is couched under how Adrian Bean himself testifies. It may be a situation where no jail calls ever need to come in to impeach. It just depends on how he testifies on the stand, Your Honor.
Yeah, I will assume that the judge will make a ruling during the testimony. I don't know because I haven't got his ruling or his lack of thereof yet. Skipping ahead.
So you're not planning on playing what's in state's, I should say, motion number 4, this jail call, unless depending upon how Mr. Bean testifies?
That is correct, Your Honor.
Okay, all right. Mr. Steele?
Yes, we are following today's hearing. We are 20 minutes behind. They have, this judge was 95 minutes late to a 3-hour scheduled hearing. So we will follow this hearing through. Then next subject will be the last remaining public defender wanting to recuse herself. And then we will talk a little bit about YSL Mondo and Fannie Willis after that. So we have a full day of stuff to talk about.
No, I don't think that the context will be needed. Mr. Bean, in his statement, which is recorded to Detective Quinn on the 17th day of September 2013, was asked to account for the guns, and he states there, Jeffrey Williams calls him Young Thug, Mr. Murphy, he calls him DK, and Mr. Prethro. But I understand what the state said, so I'm just assuming we'll take it up then because
It depends on how he testifies.
I understood.
Would be that. Let me deal with the other issue of what about the statements by Mr. Dodson, who's deceased, in the September interview.
Yes, Your Honor. The state is not intending on playing the deceased Mr. Dodson's statement to Detective Quinn.
Well, in the 17 September interview of Mr. Bean, does he reference Mr. Dodson?
Mr. Dodson is discussed, Your Honor. That interview, I'm trying to think because I wasn't, with the motions that were filed, I did not have the time hack for Derek Dodson's reference with Adrian Bean's statement. I focused on the jail calls. However, I will look at the context that I pulled up now, Your Honor, to see how he's referenced. And Detective Quinn is also coming to testify. And so, depending on how Mr. Bean testifies, I think impeachment of Mr. Bean could come either from Detective Quinn's own mouth as an impeaching witness or portions of that statement. So I think that is best addressed after Adrian Bean testifies, because neither the jail call or his interview will be coming in before Mr. Bean himself has testified and been subject to cross-examination.
And it may not come in then, right?
Correct, Your Honor.
All right. Mr. Steele?
I'm tracking, Your Honor. I understand we're going to wait. That's what it sounds like. You may not, at this point, no one's playing it, and if it becomes right, we have to raise it to the attention of the court. If I'm wrong.
No, you're correct. My only concern is depending upon what Mr. Bean says, the 17th of September interview that may reference a decedent may be a problem. That may or may not, we may or may not get to it.
I understand.
But Mr. Steele's assertion is that because Dodson's deceased, that references to him, that Ms. Dodson, would be hearsay and confrontation. But you may not get to them.
Yeah, that's the state's assertion, Your Honor, at this time.
Okay, but I'll tell you right now, you're gonna have a problem if Bean's interview states a decedent third party. I'm just gonna tell you that right now. So I think that depending upon how you can cross that bridge when you get to it, depending upon how Mr. Bean testifies. But before you start playing an interview that references a third party decedent, we need to relook that issue. Okay.
Understood.
Okay. All right. So I'll continue for ruling on that issue until we hear whether or not Mr. Bean's phone call on the 13th of September becomes relevant, as well as his interview on the 17th of September becomes relevant. Okay.
Thank you, Your Honor.
All right. Okay, let's talk about the DNA reports for overt acts 5, 6, and 7 that were supposedly served by the state on the 19th of January, 2024.
January 19th of 2024 was way after. That's not even a month ago, in the middle of trial. It shouldn't, in my personal opinion, the prosecution said they were ready for trial in November of 2022. They started jury selection in January of 2023. They were done in November 2023, and the court started early, and the trial started early December. Now, 2.5 months later, 3 months later, they're making a hearing almost 1.5 years later, after they were ready for trial. They want to have new evidence in. It's ridiculous. It's completely ridiculous and shouldn't be allowed, full stop. But here we are.
Are there DNA reports that were served or disclosed? Yes, sir. Okay, all right.
Yeah, this is the DNA report that was just thrown in the lap of the defense. And the prosecution wants it more or less next week, the testimony and the report and everything, which gives the defense less than a week to find their own expert, to look at the report, to have something to cross-examine with. It's ludicrous that he even takes this into consideration.
Yeah, and this is motion limited, Mr. Williams, number 43.
Yes, sir.
So what happened is it's the same incident. It's over Act 5, 6, and 7. There's mention in the discovery before January 19, 2024. There's mention early on, Investigator Crandall, he's with the Fulton County District Attorney's Office at that time. He states in his memo about this incident but did not charge Mr. Williams when it was prosecuted originally in 2013, 2014, that the DNA came back. There was DNA and it comes back to Mr. Walter Murphy. That's the only DNA I have at all on the case. Then on the 19th, for the first time, I have a DNA report. And what the report says is it was written in 2014, Your Honor. I have to check my memory better, but I'm going to tell you it was early 2014. April 10, the Honorable Mr. Adams said 2014. And what it basically says is there are 3 guns. We can show you a copy, actually, if you need to see it. But there are 3 guns found in this car that careened off and into the laundromat. 3 guns are recovered. DNA from one of the guns comes back to Mr. Walter Murphy. The other, there's more DNA that cannot be traced back to anyone. The suspects, as the court may be familiar on GBI crime lab reports, it says that the victim is Mr. Dotson and the 3 suspects are Mr. Prothro, Mr. Murphy, and Mr. Bean. So the first time I see this is January 19, 2024. Then on January 25th, 2024, the prosecution served for the first time the CD of Dr. DNA expert, I pronounce it Pfeiffer, P-E-I.
CD or CV?
CV, so you're right, CV.
Okay.
His resume, CV. P-I-E-F-F-E-R. He's now with ATF.
Okay.
Still doing DNA. I called him, the Honorable President Hilton gave me his number. I believe it was yesterday. I couldn't find his number. And I emailed him. He returned my call today. I called him yesterday. I emailed him today or yesterday as well. He did call me back today, and he said we could schedule a time to meet. I've also contacted DNA experts. They need more information. But, Your Honor, expert Pfeiffer has never been on any of the witness lists. I'm including any of the witness lists, 770 people, whatever the number is. Never been mentioned before in discovery. And I was under the impression that there is no DNA whatsoever. And now I find myself in the midst of trial trying to understand if this is exculpatory. I know it doesn't mention Mr. Williams. I understand that. But the way the report reads, and I do have to speak with the expert, but the way the report reads is that it's inconclusive whose DNA is in there. So I want to know, why is it inconclusive? So I've spoken with, the court may be familiar with Dr. Hampikian. He's a DNA expert. I've spoken with other DNA experts, and they are figuring out from the one report whether this DNA can be extracted and tested after they have no idea, basically.
When are you supposed to meet with Dr. Pfeiffer?
He said that he could be available today or tomorrow. So I have to email him back once court ends.
And once you talk with him, will you be able to determine whether or not you will need more?
I think so.
Information?
Yeah, I may need to. So I'm dangerous because I've done DNA cases, but I don't know what I'm doing. So I probably need to have an expert on the phone with me with his permission to make sure that I'm not misunderstanding what he's telling me or asking the proper questions. So I'm probably gonna have to coordinate with another expert and get their times as well. But I will do that. But my bottom line, Your Honor, is the same thing, that I wrote in my motion. I really don't want this coming in at all. I don't know why I got it late. It was back in 2014 is when the report was generated. I don't know why he's not on any witness list. It's just, to me, I'm in the middle of trial. This is a big case to me. And what I mean that.
I completely agree with Mr. Steele here. And I didn't know this report was from 2014. And not until January 19th of 2024, he gets it. And the prosecution wants this Pfeiffer guy as a witness. They already have 770 witnesses. And the court had told the prosecution, trim it down. And what do? They expand it. Yeah, this, I agree. This is an ambush, and it's probably completely irrelevant. It should be thrown out without any consideration of the prosecution's arguments here. I thought after covering this since May of last year that I wouldn't be surprised. The prosecution trying to get it in is not surprising. The fact that the judge even entertains the thought of letting it in is surprising, because it's so ludicrous.
I mean, there's so many people that we're interviewing constantly, Mr. Adams and myself, as well as the team. It's not just Mr. Adams and myself. I mean, there's a bunch of people trying to do this. And at some point, I just don't think it's right. So that's why I raised it to the court. And I'm not saying it's inculpatory. The state never said it was inculpatory.
That's my concern also about a blanket exclusion. And that's why the appellate courts have indicated that the remedy is, the first remedy should be for you to have more time to investigate that particular issue of continuance.
That is pre-trial, Judge, and you know it. That's when he will get more time so you can postpone the trial, not during trial.
So, without me knowing, or the court knowing the flavor of the evidence, because it may be inculpatory or exculpatory to you and inculpatory to somebody else. So, without hearing from that expert or getting the ground truth, I'd be hesitant to rule upon that issue to begin with.
Okay.
At this point, but I share your concern in terms of, we keep kind of having to address this issue, but it's the best one that I have at this point in time.
Can I mention one other thing before I sit down? I just want you to know, and I am not casting aspersions at the prosecution, but remember the court ordered, hey, get him a real witness list by a certain date, and the state pared down to 400 and, I don't know the number, 80 witnesses, I don't remember the number. There were 6 people for Adrian B. 6 what? 6 people to testify about the overt act 5, 6, and 7. There are now 17, including this doctor who's never even mentioned or his report. So it concerns me that this is how we're treating each other. And I'm not saying it was done for gamesmanship, but it was done for whatever reason, oversight, whatever. So anyway, that's my concern. But I will speak with him. But I do want the court to realize that I am asking, unless it's exculpatory, for total exclusion, even if it's even. I shouldn't be finding an expert at this point in time. That's my concern.
All right. Well, once you speak with with Dr. Pfeiffer, you can update me accordingly. But State, why are we proliferating witnesses now? I kind of told you all about that to begin with. I'm not real happy about that. So why is our witness list growing in terms of Acts 5, 6, and 7?
Yeah. He told you to trim it down and you expand it instead. It's so disrespectful for everybody involved. But here we are with a judge who is completely over his head, who is always late, wasting jury's time, the court's time, and taxpayers' money for this absolute clusterfuck.
So first, Your Honor, this is January 19, 2024 was not the first time that this report was disclosed. Your Honor, this report was disclosed actually in the first round of discovery in July 11th of 2022. It was then reserved again in September of 2023 when we did the consolidated grouping of evidence. And I can show or direct Mr. Steele to where exactly this was served previously. So January 19th, 2024 is not the first time that this report has been disclosed. It was disclosed again back in the first round of discovery in July of 2022. And then again, when we did the consolidated discovery in September.
She is misrepresenting here. what Mr. Steele is arguing is not the DNA that came back to whoever his name is. It's the other three. That wasn't disclosed. So she is in my opinion, she is misrepresenting this to the court. And I hope Mr. Steele can argue back.
Of 2023, Your Honor. As far as the witness list goes, Your Honor, I believe that this list of individuals, as we are preparing the case, these are individuals that were on the original witness list that we served, except for Mr. Pfeiffer, and we'll talk about that in a moment. But the list from 6 to 17, as we are preparing our cases, we're identifying who we need in order to make sure hearsay objections are resolved, or that we need certain witnesses to get certain evidence in. So as we're prepping the case, we're realizing who we need in order to prove that case in front of this jury. And so that is why the list.
You should have thought of that before trial. Before trial, this should have been arranged so you could have. There was a hard stop on discovery pre-trial. There was a hard stop on new witnesses pre-trial. You are using this judge's inability to follow his own rulings to get more and more and more witnesses in. I'm assuming they are doing this to have this trial move over the next election. I think this is intentional, especially now when Fannie Willis is in hot water.
A man went from 6 to 17, but we have consistently.
I don't believe. You know that I'm kind of very suspect about that.
About which part, Your Honor?
You all indicted the case. We've been through this thing about almost over about a year now. So why is it that you didn't know? I mean, it's one thing if you got one witness, okay? But, you know, I share Mr. Steele's concern that if you have a proliferation of witnesses, I'm thinking I'm going to have to deal with like 2 or 3 witnesses for a particular issue, but I got to now deal with 10. You see I might have some, trouble with in the sense that I need to look at and also interview everybody. And what it does for me as your trial judge is it kind of, I got to stop like I'm doing now and kind of look at things and determine whether or not, or give people the remedy of a continuance.
But Your Honor, first, as far as the witnesses, there's only one witness that they're saying is at issue, not the 17. They're only claiming that one person's at issue, that's Pfeiffer, because they've had the list of individuals that we plan on calling for Adrian Bean, I think, and I want to confirm, since December.
When did you get Pfeiffer?
We added Pfeiffer, I believe, I want someone to double check. When we started providing who we were calling for those witnesses, I think Pfeiffer may have been on that initial list, but I want to double check. But definitely by January, we knew that Pfeiffer might be called. And so we added him on that list that we've been providing when we thought we were going to bring this case up in January. Pfeiffer was on that list.
Was Pfeiffer on the July 11th or the July 11, 22 or the September 2023 list?
Pfeiffer was not on the expanded witness list, but he was on the list of individuals that we said these are the people we're going to be calling for this case. So when we narrowed down,
what date was that?
I need to look and see when the first iteration of that we sent out. And that was either December or January.
This is ludicrous.
So on January 5th, 2024, I have a December 31st list. On December 29th, Your Honor, we sent to all defense counsel the list of witnesses that we intend to call for all the cases that were coming up, and Pfeiffer is on that list. And when we pared down who we were going to call for this particular case, we listed everyone we intended on calling on this particular case, and that is from the 29th of December. So this is not anything new. This is who we've put on this list consistently since we've been providing the shortened list of who we were going to be calling. And again, Your Honor, the statement inadvertently left Mr. Pfeiffer off of the master list, but he has been in discovery since July of 2022.
Yeah, here is when the judge, when his decisions comes back to bite him, because he already approved of the December 29 list. So he put himself in this situation because his inability to put boundaries on this prosecution. Because if he is on the December 29 list, it's already approved. Because he keeps, we'll forward. I will allow the prosecution to do this, that, whatever's. And here we are. Him claiming, I told you to narrow the list. Well, we provided you with an extended list and you approved it. Oh, hello. Broken Baker sent over his viewers. Hey, welcome to a complete cluster F of a hearing. Welcome to the Young Thug YSL RICO trial. Hello, Bakers. We are having a hearing about DNA evidence that wasn't disclosed to the defense until after trial started. Me raid. Thank you, Baker. Yeah, welcome to the shit show. Yeah, as I said, and this so-called DNA evidence is from way back in 2014. Now, it wasn't disclosed to the defense. The prosecution claims they did, yes, but not the part you now want in. Now, the report you had disclosed to the defense was regarding DNA on one gun. There was 3 other guns in that car. And now you want to have evidence in about they couldn't test, there was inconclusive DNA results on the other 3. In the middle of the trial, trying to argue that one of these inconclusives belongs to Mr. Williams. In the middle of the trial. It's infuriating. Go back 20, you new here, go back 20-25 minutes and then speed up. And you will know why I'm acting this way. It's infuriating.
This is not anything new, Your Honor, so we would ask that this report not be excluded. Mr. Steele has had the opportunity to at least have an initial conversation with him and potentially we'll have any further conversation, Your Honor. But first and foremost, this is not the first time that we disclosed it on the 19th, and they've been aware that we were going to call this particular witness at least since December when we were given the pared down list of who we were going to call and that we intend to do so that we can move forward with this trial, Your Honor.
When's Dr. Pfeiffer going to be called?
Your Honor, it will be all really contingent upon what happens with Investigator Belknap. We perceive that this particular case will be called next week. Mr. Pfeiffer.
Yeah, this new witness, this new part of the report that was handed in the lap of the defense last week, they want to call next week before they... She's screaming because she thinks she's going to lose this argument with the judge. Here's the thing. The judge has painted himself into a corner by already allowing, after trial started, new evidence and new witnesses. So he's painted himself into a corner here. And I don't think, I still say it's wrong, but he shouldn't have done this to begin with. Allowing the prosecution to add new evidence and new witnesses when the extended witness list for the prosecution is 770 witnesses. I'm not joking. The prosecution's witness list in this trial is 770 witnesses.
Lives out of state, and so it's the state's intentions to fly him in so he can testify on a particular day, but we're just trying to figure out once Investigator Belknap's testimony is completed, we're just trying to determine when we will fly him in, but ideally it will be at some point in time next week.
Okay, all right. Mr. Steele, I'm not going to exclude the report from Dr. Pfeiffer, but I will give you enough time to talk with him and to make other arrangements should they become necessary. So see what he says, and you can report back to me, okay?
Of course. Here's the thing. The defense in November were prepared for a witness list of around 450, something like that. That was what they were preparing for, with interviews, everything around that. Then the prosecution added on 300 people. And then in December 29th, they added on additional witnesses. And now in the middle of the trial, they're adding on completely new witness that will be called next week. How in the living F is a defense who already have to prepare for 770 witnesses? This is ambush. It should not be allowed, but this judge has painted himself into a corner by allowing the prosecution with garbage argument to add on an already inflated witness list. And now, because he started doing that, if he stops doing that, that's an issue for him as a judge. It's infuriating. This judge is way over his head. But he can't admit to it because he is the chief judge in Fulton County. If Williams lose, will he win on appeal? Appeals are for losers. There is so few cases that wins on appeal, it's ridiculous. We are not talking less than 1% wins on appeal. So it's now or never. They need to win this trial now. And according to me, in my personal opinion, this judge is helping the prosecution do their case. He should not. He should be the gatekeeper in both directions. No defense, you cannot do this. No prosecution, you can do this.
Yes, sir.
Okay. All right, folks. That's kind of I think that's a wrap for today in terms of what we're going to be able to take up in terms of. So we covered 42 and 43.
Okay. Oh, again, the judge. This hearing was scheduled for 3 hours. The judge was 95 minutes late, an hour and 35 minutes late, because he had a meeting with legislators. He didn't reveal who those were, but whoever they were, whatever this hearing, I mean, there's, I think, an additional 5 or 6 motions that should have been handled. And they simply didn't have time to, because judge was 1 hour and 35 minutes late. Yeah. You know, I'm going to send an invite to Baker. He was so nice to send you all over here. Hold on a second. If he's still here, I sent him a link. Because now, next item on the list. Oh, hold on. There. Next item on the list is the last remaining public defender in this trial wants to recuse herself from the case because she can't afford it. For you who don't know, who are new here, originally, the defender's office, whatever's, was budgeted $15,000 for the public defenders in total for the entire trial and entire pre-trial and all the hearings. Now, once the number of public defenders are gone, it's just her left, Miss Angela de Williams. Now they have extended that so she can get paid $55,000 for the entirety of pre-trial and entirety of trial. That's nowhere near enough. That's not even minimum wage regarding all the hours she has to be, because she has to be there every trial day, every hearing day, and she had to be there all the hearings pre-trial. It's ridiculous. But let's find out more about her reasons. So let's see here. There she is. You might have seen her in the background in very colorful outfits. Young Thug trial. Defense attorney asked judge to let her withdraw from case. And this is from Fox 5. That's there. An attorney representing one of the defendants in Fulton County RICO case against Young Thug and his YSL associates has asked the judge to take her off the case. Angela de Williams is the only lawyer in the trial who has been appointed to represent one of the defendants on a contractual basis and says the amount she is being paid is too low for her to continue with the trial. Yeah, I mean, even if it's 50, even if they raise the cap to 55,000, it's still so it's not nearly enough. It's not nearly enough. Let's see here. No, not that one. Definitely not that one. That one. Okay, let's do that one. See here. Hold on. The Williams, who represent 19-year-old Rodelius Ryan, wrote a letter to the Georgia Public Defender Council saying that she has been left with minimal time for other professional responsibilities. Yeah, as in no other cases, because she's up to her eyeballs in this case. She can't do training courses because she has to devote all her time for this. I mean, this is her full-time job and has been for a year and a half. And she's getting paid as a lawyer $55,000 for 18 months. And the remember, this trial will go on for at least 6 more months. And she will not be paid anymore. This is not the first time the Williams filed a motion asking to withdraw herself from representing Ryan. Last April, she argued that her pay of $15,000 was too low for a case that could last a year. Now, after months of jury selection and weeks of hearings, she says the increased pay cap of $55,000 is still too low for her to live off. I'm not able to take on new clients because I'm either in court for this trial or outside of court working on this case the majority of my time. As such, I'm not able to earn a livable wage while representing Mr. Ryan in this trial, the Williams wrote. The Williams argued that she has adhered to her agreement, but that the unique nature of the case has created an undeniable need for additional financial support. Legal Affairs and Trials reporter wrote that the chief legal officer for the Georgia Public Defense Council agreed that her situation was unusual, but said that they would not be able to accommodate another pay increase. De William is now asking Judge Uriel Glanville, who is overseeing the trial, to allow her to withdraw over the objection of Ryan, who she says will not waive his right to her appointed counsel. After a motion in 2023, the GPDC asked to have her taken off the case, arguing that the public defender claimed that she wanted to withdraw from the case, but revealed in private she did not. Yeah, this is a play on her. Please, I need more than minimum wage for this trial. And I agree with her tactics, even if she revealed in private that she didn't. I assume she really doesn't want to be off the case. But here's the thing, $55,000 over, let's see here. Let's do a rough, okay, hold on everybody. Nick is doing math. Dun, 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 $55,000. Okay. She started this case on this case as a public defender in, I believe it was somewhere around October or November of 2022. So that is a year and 4 months. So it's 16 months. So let's divide $55,000 with 16. That is $3,437.50 per month. And that's to now. Let's say let's say this trial goes through the year. Another 10 months. For argument's sake. Let's see here. Yes, I'm using a calculator. Clear 55,000. That is 10 more months. That would be 26 months. Divided by 26. That is $2,115 and some cents per month. That, I mean, it's ridiculous. Yeah, business expenses. She might have an office. But that's it. That's the entirety of what they're going to pay her, $55,000. And that is still a huge increase from the $15,000 they were going to pay her originally. But $55,000, if the trial ends mid-December, that means she's earning, before taxes, before expenses. Where did it go? Where's my calculator? There. $2,115 a month. It's insane. No, MG Law, not over the next 10 months. This is in totality of her entire appearance as the appointed lawyer for Mr. What's his face? So she's already been on the case for 16 months. So if it were $55,000 over 10 months, yeah, that you could, as a lawyer, yeah, maybe, but not expenses. Yeah, and her client is only named in one overt act, and she has to be there for everything. Because in the RICO Act, Georgia RICO Act, he is equally guilty of the other people's crimes if convicted. And he is only mentioned once. So if this goes on for the entirety of this year, 2024, she's been on the case for 26 months and is paid $55,000. No, totality. They increased, let's see here. Where was it? That's the increased pay cap. So the pay cap is $55,000 in totality. And you tell me again this is the state who decides what to pay the public defenders. How is that even come close to being a fair trial? How does that even come close to a fair trial? Please explain to me. Because it isn't. It's this in its foundation. This is not a fair trial. Because the state is handcuffing the defense by not paying them enough. Now, luckily for Mr. Ryan, Mr. Williams has a good deal of money, so she can rely on Mr. Steele and his resources. But here's the thing. She represents Mr. Ryan and Mr. Ryan alone. If she believes that the right conduct for Mr. Ryan is to throw everybody else under the bus, she can do that. And she should, if that is what she believes is the right thing for her client. Because they are all representing their own client in this. It's infuriating, this case. Simply infuriating. Where were we? Glanville has reportedly scheduled a hearing over de Williams' motion for Friday. So yeah, this Friday, this will be a hearing. So it's already half a day in court on Friday. And parts of it will be over de Williams' motion. She's a contracted public defender. Because at the beginning of this case, there were 28 defendants, and they had to find public defenders for all of them. And the public defender's office, well, they can't represent more than maybe a handful, because after that, it becomes a conflict of interest. So they had to go outside to private practices to find other people prepared to defend the people in this indictment. After a year, as in, I believe, August of last year, there was still five people in jail still awaiting a bond hearing because they didn't have representation. Now when they are down to 6 defendants and a lot of people have pled out or simply charges dropped, now there should be enough money in the budget to pay Mr. Williams an honest salary for this. But they won't, because Fulton County, in my opinion, is so corrupt. They should tear it down and build it up with completely new people, in my opinion. Yeah, and that was that. Now, next subject. Dun, dun, dun. Oh, I forgot one thing. I forgot to swoop. That's the Norwegian fire-farting dragon. Now, let's talk about YSL Mondo. This you will find interesting. Dun, dun, dun. Bum, bum, bum. There she is. Oh. Fannie Willis was a lawyer for a YSL co-founder. That is YSL Mondo. YSL Mondo was charged back in 2019 for something, I don't care. He was charged for something big. She was his lawyer. She got him to plead to a lesser charge. So, the district attorney, it's not a conflict of interest because YSL Mondo is not in this trial. He's not mentioned in the charges at all. He's completely removed from everything regarding this trial. That's why this is not a conflict of interest. My opinion, and I've said it before, my opinion is there is a high likelihood that the very foundation of this RICO trial is based on information Fannie Willis got from YSL Mondo as his public defender. Why do I say that? Well, we now know she is a lying liar who lies. With her affair with a married man, Mr. Nathan Wade. Now it's just an issue, when did that affair start? For me, personally, I don't care. She stood in church in a sermon for Mr. Martin Luther King, the day before Martin Luther King Day, and she lied in church. That has been revealed. One of the things that she lied about was how she paid the three special prosecutors. She claimed in church they were all paid the same hourly salary. Now we know that was a lie. Another lie is things she reported in the press. No affair. Mr. Nathan Wade, in a sworn affidavit in 2023, in his divorce case, said there were no affair. Now, in the disqualification case, Mr. Nathan Wade acknowledges that there was a romantic relationship with Miss Wade in a sworn affidavit. But Nick, how does that compute? If he said in a sworn affidavit back then and a sworn affidavit now, two different things. Doesn't that mean he's lying? Yes, it does. What did he do? Well, we saw that yesterday. He corrected his previous affidavits where he claimed I did not have relations with that woman, Your Honor. He exchanged that with pleading to the Fifth Amendment to not incriminate himself. My limited understanding about the Fifth Amendment clause and plea and stuff like that, I'm not sure he can use it, because he can only do it if it criminally incriminates him. So how that also means that I mean, you have to read a bit between the lines here, and maybe a US-based lawyer can tell me to shut the fuck up or something else. But if he only can plead the fifth for self-incrimination in a criminal matter, that means that it is what he did was actually criminal. And the only crime Miss Willis is accused of, and not the only one, but one of them, for disqualification at least, is that the relationship started before he was appointed special prosecutor. That's my logic, at least. So we have here two lying liar who lies. She is an adulteress. He is a man whore. Why should we believe her at all when she's... And now bring that to the YSL Mondo thing. Why should we believe a prosecution that removes YSL Mondo completely because of conflict of interest? And my logical conclusion in this is that Fannie Willis broke attorney-client privilege to get the foundation for this RICO trial. That is my conclusion. Do I have all the evidence I need for a prosecution or for a lawsuit or everything? Of course not. I'm here, law tuber, not even an American lawyer. Yeah, and as Matt says, I don't really care that he is a man whore and she is an adulteress. I care she paid her lover with public money. Yeah. And he, in return, got her on trips, on cruises, travels, dinners, all of that stuff. That is illegal. That is handling public money fraudulently. Which brings us back to Mr. Wade's affidavit that he changed and is now pleading the fifth. And that is why tomorrow's hearing in the Trump RICO case kind of takes precedent for me regarding what I'm supposed to stream tomorrow, because that has so many implications on even this trial, possibly, that I will still do a recap tomorrow evening or tomorrow afternoon. But I need to hear what's going on in the Fannie Willis disqualification hearing. That is why tomorrow will be that hearing and not the Young Thug trial, because it has implications possibly towards the Young Thug RICO. I don't know that this is what was said during the yesterday's pre-hearing by Miss Merchant to the court yesterday in the pre-hearing, the evidentiary hearing before tomorrow's hearing, because yesterday they handled a lot of motions to quash, and more or less every one of those motions. Oh yeah, the district attorney's office, the district attorney had her entire staff signed NDAs. And the only way for them to talk to anybody about what's going on in that office is via a court order. And I really hope that court order comes tomorrow. Oh yeah, I forgot. Nathan Wade has refused service of his subpoena for tomorrow's hearing. The judge more or less said, well, that's not going to work. Carlos Lomax, isn't that a conspiracy to defraud the state? Yeah. Also because invoice 22 and invoice 25 paid to Nathan Wade is missing. They have no record of what those invoices actually were in the district attorney's office. That's 2 invoices for, we are talking about hundreds and thousands of dollars that the district attorney's office, the only record they have, according to Ms. Willie's lawyer, is the payment to Mr. Wade, but not the actual invoices. We simply don't know. So yeah, defrauding the state, and that still doesn't include the federal things that might come later, because Fulton County Prosecution's office got a big sack of money to clear the docket in Fulton County from cases. So money that is paid to Nathan Wade might also be federal money. You don't want to mess with feds money. That's now it goes up to an entire new ballpark, but that's not what they are talking about tomorrow. Now, a bit more about, because there is one quote here. Hold on. While I make there. One quote I really want. This is YSL Mondo. This is not her character. This is not who she is, he says during a phone call. I done had auntie to nephew, mother to son type talks with her. I know this is not her character. This is what made me start looking at the YSL case. Like, I know it's bigger than just her. It's politics behind this shit. It's other people that's behind her pulling strings. I'm not so sure. I think in 2019, Miss Willis already knew she was going for the district attorney position. She already knew. I think, can speculate, that his words here is him very naively thinking that, oh, we had a great relationship, like mother to son, auntie to nephew. Yeah, that was her gathering information, allegedly, for future RICO trials. Can I prove it? No. Absolutely no. But this is my logical conclusion regarding Fannie Willis, is the basis of the young Thug RICO-Trial. The foundation of it is information she extracted from YSL Mondo, and that's why he's not in this case at all, because he's not a defendant, so nobody can call him to testify. Because if somebody calls him to testify and he has to reveal, because he can waive attorney-client privilege. Willis can't, he can. So if he, for some reason, and I pray to whatever God you pray to, that the prosecution fucks up and makes YSL Mondo available. Because I'm quite certain that his testimony about conversation he has had with Fannie Willis will reveal that she was gathering information for the foundation of this RICO trial. I think she is that kind of corrupt. I believe she's that kind of evil. Because if you can lie in church on a Martin Luther King sermon, It's not illegal, but still evil. All right, that is all I have for today. That is all I have for today. Any questions I missed? If you have any, please write them while I look for people to redirect you to. Dun, dun, dun. Redirect. And please consider becoming a member and gifting memberships or something of the sort. I would deeply appreciate it because of all the words that was said, all the N words, I can't monetize this at all. So if you have something to spare, I would deeply appreciate it. Let's see here. Who are on now? Oh, Sal is on. Salvador Dali Talk is covering the Darren Lopez trial. But, so we'll send you over there. But, yeah, everyone, you know what I say. Remember to hug your family. Unless your family is shit, then fuck them and give your love to the people who deserve it. Okay? Thank you for allowing me to present this trial to you. Okay. See you tomorrow. Bye-bye.